Hello, and welcome back to our second lecture on legal aspects of genetics. This time we're going to be talking about one of my very favorite topics, which is human gene patents. To get started, as most of you already know, over the past decade, genetic testing has increasingly become an essential and even routine tool of clinical diagnosis. Medically relevant genetic testing is an integral part of health service provision and can significantly improve an individual's quality of life by providing knowledge of diseases and treatment options. At the same time as many of these genetic tests have been being developed, the European Patent Office, which I'm going to be referring to as the EPO, has been granting patents on human genetic products and related processes. Experts have in fact estimated that patents have been filed or granted for nearly 20% of the human genome. So this has led to a lot of debate, a lot of public outcry, both on the suitability of human gene products as a patentable invention and on the potential negative consequences of gene patents for innovation and for patient access to diagnostic testing and to therapeutic products. So in this lecture, we're going to be discussing this controversy. We'll start by looking at what exactly patents are and how they work, and then we're going to consider whether human gene products are a suitable subject matter for patents. We'll also talk about the legal status of patents in the UK, and then we're going to talk about some of the consequences of patenting in human genetics. And finally, I'm going to want you guys to have a discussion on what you personally would do if you, in your practice, you were to find yourself having to consider human gene patents, which, based on what I've heard about you guys, I imagine many of you will in fact have to be addressing at some point in the future. So this discussion that you're going to be having can be based around the Hawkins paper that Professor McKay gave you on the impact of human gene patents on genetic testing in the UK. So finally, the last thing that we're going to do is I'm going to conclude by going over a few of the proposed solutions to various problems that have been posited in relation to human gene patents. So let's get started. All right, first topic, what is a patent? A patent may be defined as a grant by the state of exclusive rights for a limited time in respect of a new and useful invention, usually limited to the territory of the state granting the patent. So to break this definition down a little bit, the first part is a grant by the state. So this indicates that a patent is not an inherent right that arises naturally, for example, through the labor invested in innovation by the inventor, but rather it's a right that only exists once it is granted by the state. Second part of our definition, exclusive rights for a limited time. So this means that it is, by exclusive, we mean a right to prevent third parties, without the owner's consent, from acts of making, using, offering for sale, selling, or importing the patented invention. So note here that a patent does not grant the right to use the invention that's being patented. So an example that illustrates this point is that you can get a patent on a bomb, but that does not grant you the right to make and use that bomb as you see fit. So also in this section we have that the exclusive right is for a limited time, and that usually means that the patent will expire after 20 years, assuming that all necessary fees are paid to maintain the patent, and that it's not challenged in court as being invalid. Next part reads, in respect of a new and useful invention. So this describes the types of inventions that can be patented, which we will look at in quite a bit more detail in a moment. And last part here, usually limited to the territory of the state granting the patent. Oops, sorry. So this indicates that patents are country-specific, usually. But if you have a patent in, so normally if you have a patent in the UK, you would not be able to enforce that patent against someone who's using your invention, say, in France. But that said, there are mechanisms in place, which are structured by the EPO, the European Patent Office, that allow prospective patent holders to make a single application and have a patent granted across a number of EU countries. It is important to note, that being said, that patent laws, while widely congruent, can differ slightly from country to country. And so even if you make an application that allows you to apply for a patent in a number of different countries at once, those patents still will be country-specific. Okay, so let's go into a little bit more detail on the characteristics that a product or a process must have in order to be patentable. So first of all, a process or product has to be an invention, not a discovery. So we can consider this distinction in a colloquial sense. So for example, a discovery is something that exists before you find it, whereas an invention is something that you create yourself. Patent law, however, is very specific, has a way of distinguishing these things according to a specific legal test. So that test is that an invention must solve a technical problem by a technical means. So what that means is that it has to contain some sort of technical contribution to the so-called state of the art. So another way to think of this is that a discovery involves extending what scientific knowledge already exists, whereas a patentable invention is about increasing the professional skill in the field. So again, technical application of the knowledge discovered in a technical field, very technical. Additional characteristics, once you know that something is an invention, you have to make sure that that invention is novel. So this means that it has to be new, and again, there's a fairly specific legal test for this, which is that the invention has not been presented to the public, for example, in an academic publication or presentation, prior to the filing of the application for the patent. Second characteristic, in order to be patentable, an invention must arise from an inventive step. This is also known as the non-obvious criteria. So again, a fairly specific legal test, which is that the inventiveness of a if the inventiveness of a patented invention is challenged in court, the judge will consider whether a person, so-called of skill in the art, somebody skilled in the technical field, at the time of the invention, would have considered the new product or process to be obvious or not. Said at the time of the invention there, by that I mean at the time that the application was made for the patent. So third characteristic, in order to be patentable, an invention must be useful. So this is also known as the criteria of utility, or more commonly in Europe, it's referred to as industrial application. This characteristic is related to the invention discovery distinction in that the invention must have some practical application. And in fact, one that is specific and real, not just sort of theoretical or hypothetical. So those are the criteria that a patent invention must possess in order to be patentable. But of course, there are some exemptions to this. So an example of a process that is exempt from patentability is methods of treatment for the human body by surgery, or therapy and diagnostic methods practiced on the human body. These methods are not to be regarded as inventions susceptible to industrial application for moral reasons. It's important to note, though, that this is a very narrow exception. So it doesn't apply to in vitro methods, but rather only to purely intellectual processes in which medical professionals engage. So we also have an exemption which is specific to the European context. This one doesn't apply in the US or in North America. And that is that inventions, the publication or exploitation of which would be contrary to public order or morality, cannot be granted a patent. So again, this is a very narrow exemption. There must be a really strong social consensus that a practice or product is deeply offensive in order to trigger this exemption. So it's in fact very rarely applied. One example where it has come up is in claims on entire mammals. So an example that you might be familiar with is the Harvard oncomouse, which is a strain of white mouse used in research that has been specifically bred in order to be predisposed to cancer, because it makes it easier to use them in research. So a patent was granted on the Harvard oncomouse because the idea was that the benefits for human beings outweighed the suffering of the mice. So that's one example where a patent was granted, but in that case it came up that other mammals were still invalid for patenting purposes, as to patent a mammal was seen as being contrary to public order and morality. So there are some broad exemptions to patentability, and certainly more so in the European context than in the North American context. But generally these only apply in a very limited range of circumstances. They come up very rarely. And so overall, it's safe to say that the trend is to allow and even to encourage patenting of new inventions, as long as they're novel, inventive, and useful. This leads well into the topic of why we have patents, or why they exist. So the theory that has been used to justify patents historically, and that continues to be asserted today, is that patents promote research and innovation by ensuring that innovators will be able to capitalize on their inventions and earn back some portion of the resources that they expended in research and development through their limited monopoly right. So the bargain, so to speak, is that society will grant this limited monopoly right, which is a short-term right of economic control over the product or process, in exchange for the disclosure of the new and socially beneficial innovation, which patent holders might otherwise be inclined to keep a secret, so as to prevent others from free riding on their work. So this brings us back to a point that I made previously about how a patent is not an inherent right. An innovator does not earn a patent, for example, through the labor that they put into innovation, which is a common misconception, but rather a patent is granted by the state in exchange for a very specific sort of social benefit. So, while this is the traditional justification for patents, the question of whether patents actually work in this way to promote innovation, particularly in the field of biotechnology, and whether patents are necessary in this respect, or whether innovation perhaps would occur even without patents, is very much up for debate. Many people have argued that patents can in fact inhibit innovation in some fields, and in biotechnology in particular. So we're going to discuss that in a moment. First, before we start talking about the impact of patents, we need to address the issue of whether human gene products are even a suitable subject matter for patents, given the patentability criteria that we discussed and the exemptions as well. So, as you may have guessed from the paper you read in preparation for this lecture and from my introduction, human gene patents, including entire gene sequences, partial sequences, and single nucleotide polymorphisms, have been patented in the UK. Additionally, many genetic diagnostic tests have been patented, which effectively provides a monopoly on the underlying gene, since such patents limit access to the analysis of the genes being covered by the diagnostic test. So, according to the OECD, genetic inventions include nucleic acids, nucleotide sequences and their expression products, transformed cell lines, vectors, and methods, technologies, and materials for making, using, or analyzing such nucleic acids, nucleotide sequences, cell lines, or vectors. So it may seem counterintuitive that you can be granted a patent on these kinds of products and processes, since, as we previously learned, you can only patent inventions and not discoveries. It's a very common assumption that human genes are something that is discovered rather than something that's invented. The Patent Office has avoided this concern by finding that only artificially produced versions of the products that I described previously, as opposed to these products as they exist in the human body, can be patented. So any genetic substance that can be produced using artificial means, as with isolation and cloning of a gene, is regarded as an artifact or a man-made invention, and is therefore eligible for patenting on the condition that the substance, its function, or a method to produce it is an invention, which means, of course, it has to be novel, have a specific disclosed function, is not obvious with respect to current knowledge, and can be applied industrially, as we discussed above. While many patents up to this point have been granted on these grounds, it is important to note that currently mere isolation or characterization of a naturally occurring biological material is no longer sufficient for patentability. That's because current technology has rendered these kind of practices routine, indicating that such an invention would be obvious. Also, the entire human genome has, as I'm sure you know, now been sequenced and published, so the characterization of any given gene at this point would also be obvious. That said, the law in this area is mostly untested, and so there's a lot of uncertainty around what exactly is patentable and what is not. So having established that human genes are patentable in our current system, I want to spend a minute talking about the justifications for this before we get into the criticisms. So as I mentioned previously, the premise of the patent bargain is that patents incentivize innovation by ensuring that researchers who commit many resources to developing time and labor-intensive inventions will be able to obtain compensation for their work. So when genetic inventions first started appearing on the market, they were analogized to pharmaceutical inventions, where patents are thought to be particularly essential. So in that context, due to high regulatory standards, new pharmaceutical products can take over a decade to develop, because they have to go through all kinds of clinical testing and so on. And they typically cost millions of dollars to bring to market. Many products additionally fail due to lack of effectiveness or overly negative side effects. So the return on successful products in the pharmaceutical industry has to cover the cost of those that fail. That said, once a product makes it to market, it is easy for generic competitors to reverse engineer chemical formulas and immediately benefit from the labor of the innovator company, of the person inventing the new pharmaceutical. So in order to prevent this, and to ensure that innovators will be able to charge the prices they need to support ongoing research and development without their profits being appropriated by their competitors, the theory is that patents are essential. So according to this theory, it is worthwhile for society to grant patents, even when it increases the price of research and diagnostic tools, since without patents, those tools might not exist at all. So there's a number of ways in which genetic research differs from pharmaceutical research, which is perhaps problematic for this theory. But this does explain, historically, why patents were initially granted on genetic inventions, because regulators wanted to promote innovation in the field. So now that we've established the theoretical benefits of gene patents, we can start to consider objections to this practice. There are two main categories of objections to the patenting of human gene products and processes. The first is deontological or principle-based, where arguments generally assert that there is something fundamental about the nature of the human body or human society, or even genes themselves, that militates against granting patents on these kinds of inventions, regardless what the consequences are of gene patenting. So in this category, we have objections based on the idea that patents on gene products and associated processes are capturing discoveries instead of inventions. Even for diagnostic tests, for example, what is novel about the so-called invention and what is of value is the association between the gene or the mutation and the disorder, not the physical process of testing itself, which in many instances is nothing more than the application of a well-known method, albeit to a newly identified gene. So I have a lot more to say here because I spent an entire summer writing an opinion piece about this, but for the sake of brevity, I'm going to leave it there. So next up is sanctity of life or human dignity arguments. These say essentially that there is something inherently wrong about allocating ownership rights over products of the human body. It's my opinion that these are not particularly rigorous arguments, since the idea of sanctity of life or of human dignity is quite vague, and they're concepts that can easily be used to justify a lot of different positions. So I'm not going to go into a lot of depth on this one, but you're welcome to discuss it further if it interests you. So the third type of argument that we have here is often referred to as an argument based in fundamental justice, which is associated with this idea of the human genome as the common inheritance of man. So this is an interesting one because we see the human genome being analogized to the high seas, which are conceptualized as a global commons or a global resource, in the sense that the ocean, at least in international waters, is a common good from which no one should be excluded. So to assign ownership rights over this common good is to make it exclusive, which is contrary to its status as a global commons. The tricky thing with this is that you run into a lot of management problems, as we've seen with the deterioration of the oceans. When you have too many people who all have a right to a valuable resource in a non-controlled way, it can result in abuse of that resource. Initially promising, but I'll sort of leave it up to you to give that some more thought. And the next type of argument that we have here is arguments based in a fundamental principle against the commercialization of the human body. So I think this one's fairly self-explanatory, though it is interesting to consider in the context of our discussion earlier this morning on ownership of the human body and gene products in particular. So as we've seen, the law at least is a little uncertain on this topic, as there seems to be cases, such as in Yearworth, where ownership of elements of the human body can be seen as a good thing. So another argument that falls into this category is the sanctity of life or human dignity argument, which essentially says that there is something inherently wrong about allocating ownership rights over products of the human body. So according to these types of arguments,
in my opinion, this is
not a particularly
rigorous argument,
theory, since due to the negative consequences that may arise from the practice, proponents of these arguments,
these are quite vague
find that it should be protected. So the fear, generally speaking, in this context is that gene patents are going to unduly increase the costs of genetic research and medicine and restrict access to research materials, thereby slowing innovation and reducing patient access to genome-based diagnostic methods and therapies. So arguments in this category abound in the literature. With regards to the genetic anti-commons, which is the first thing we have here, The earliest paper on this argument was written by Michael Heller and Rebecca Eisenberg in 1998. So since then, many more papers on this argument and on versions of it have been written, though evidence of the phenomenon is still fairly sparse. So to go into a little more detail on what exactly this means, the anti-commons argument is basically that when a resource like the genome has numerous rights holders who prevent others from partaking in it, this frustrates what would otherwise be a socially beneficial and desirable outcome. So in this case, innovation in genetic medicine is that beneficial outcome. So the concept of a patent thicket is similar. The idea is that you have many patents on both upstream research tools and more downstream products that together will increase the burden on researchers because those researchers will need to obtain many licenses on many patented inventions in order to conduct their research, to the point that some research will become just too burdensome or too costly to conduct. So the second argument that I have listed here is royalty stacking, which is somewhat similar, but relates, similar to the anti-commons, but relates more to consumer costs than to licensing by researchers. So the concern here is that a person with a patent on a research tool might claim royalties on a product made using that tool. And so if this happens multiple times, it can add up to increase the price of the end product. So again, there becomes an issue of increased costs and subsequent reduced access. The third argument that I have listed here, overly broad claims, has to do with the concern that claims will be overly broad. That's helpful. So the idea here is that when you apply for a patent, you make a number of claims with respect to what you're seeking to have a monopoly over as a result of your patent. So you might, for example, claim a gene sequence in a patent where the primary invention that you're applying for a patent over is a diagnostic test. So since you want a monopoly over testing for a given disorder related to that specific gene. So the concern in this context is that such claims are too broad, as even though the gene sequence should only rightly be claimed with respect to the specific diagnostic test invented by the patent holder, once that patent is granted, with the broad claim over the gene sequence, any other researcher or practitioner seeking to access the genetic sequence, even for a completely different purpose, would be prevented from doing so. So again, the concern here is that gene patents might unfairly restrict access to genetic materials. The last argument that I've indicated here has to do with the licensing of gene patents. So once an inventor has a patent, which gives them the legal right to prevent others from engaging with the subject of their patent, with their invention, the only way that others can access that invention legally is by seeking a license to do so from the patent holder. So the concern here is that patent holders will engage in licensing practices in order, for example, to give themselves a market advantage. And I actually have a good example of this kind of behavior. So I'm now going to move into discussing some case studies in gene patenting that illustrate some of the issues that we've just been discussing. So first up is the most well-known example of a controversial gene patent, which is the Myriad Genetics case, which I think many of you might have already heard of. So Myriad Genetics is a Utah-based genetics company that successfully applied for a number of patents on the BRCA1 and BRCA2 genes, which, as you probably know, are tested in order to identify hereditary breast and ovarian cancer. Interestingly, the discovery of these mutations was preceded by a large international collaborative effort with hundreds of breast cancer families in the early 90s. The first to apply for a patent, however, despite the collaborative nature of the work, was Myriad Genetics. This suggests another reason, just a small tangent, why genes should not be patented, which is that, as with most science, valuable inventions are generally the outcome of a great deal of information sharing and communal research, and so it seems a little strange to then grant sort of the person who put the final brick in the wall complete control over that wall. But again, that is a small tangent. So back to Myriad. After being granted these patents, Myriad aggressively tried to enforce its patent rights against people trying to do testing for breast and ovarian cancer. So, for example, they sent cease and desist letters to labs that were engaging in testing without a license, and they also were not enabling people to purchase licenses, and rather insisting that all testing of the BRCA1, BRCA2 genes be done in their own lab in Utah, which was very costly and inefficient, and meant that it was taking a lot longer for people to get their test results. So this inspired a lot of resistance and mobilized kind of general opposition to the patenting of genes. One reason why there was so much of a negative response to the Myriad case was that, as in the case of many genetic inventions, so to speak, there was no suitable substitute for the BRCA1, BRCA2 tests, by which I mean there was no sort of way to invent around the patent and get the test results you were looking for without using those genes which had been patented by Myriad. So this meant that the balance of power between the large corporation and the users of the tests was very much in favor of Myriad, which I think made people feel really powerless and angry. And so that's what sort of stimulated that quite serious response. So because the cost of the test, if you were going to send it to Myriad, made it virtually inaccessible, labs around the world, including in Europe, continue to test without licenses. So they were breaking the law and they were worried about being sued. Luckily, this case eventually had a happy ending. The patents were challenged in court. All of these labs that were so concerned about what was happening with their gene testing, whether they were going to get sued, they took Myriad to court. And eventually the BRCA1 patent was revoked, and the other sort of series of patents related to these two genes were limited in scope. So the Myriad case is interesting because it frames a lot of the dialogue and debate around the patenting of human genes, and because it was sort of so explosive in the public media. So I do have a couple of other examples, some of which show that researchers have maybe learned from the Myriad case, as is exemplified by the cystic fibrosis story. So here again, identification of the relevant mutation was the result of a large international collaboration, but the resulting invention of the relevant genes was patented by the Toronto Hospital for Sick Children and the University of Michigan. So unlike in the Myriad case, these patent holders were much more cautious in limiting access to their patented inventions. So they adopted a licensing strategy whereby they granted free access to the CF gene sequence for diagnostic testing, using commonly available technologies for mutation analysis, but they collected royalties on gene-based commercial test kits and from companies offering commercial testing. So the result of this more reasonable approach was that there was far less public outcry, far less publicity, though of course there's still some element of increased costs and reduced access in this context. So another case we can consider where the researchers perhaps did not pay attention to the Myriad case and did not learn from it is in relation to Canavan disease. So in this context, diagnostic tests and treatment options were developed when parents of children suffering from Canavan disease allowed researchers at the Miami Children's Hospital to use their children's samples. So the parents of these sick children collaborated actively with the researchers to collect samples and to build a register. The hospital researchers later commercialized the results and charged high prices. The hospital researchers later developed a test by using the samples from the children and patented it without the consent of the parents. So the parents wanted the information and the test to be freely available to all, but the hospital commercialized the results and charged high prices. So the outcome of this was that the parents took the hospital to court, but eventually the parties agreed to settle on the grounds that the hospital would have the prices associated with testing for and treating the disease. So again, somewhat happy ending, but still increased costs. These examples illustrate that patents can increase the price of patented genes, increase the price of accessing patented genes, and can reduce access to research and diagnostic tools. However, this is a fairly small number of examples, and in each case, access was eventually increased or improved. So before we decide that patents in genetics are completely a bad idea, in case that's the direction you're leaning in, we should have a look at what other evidence is available with respect to these consequences that we've discussed so far, and in what way patents might actually be somewhat beneficial in the realm of biotechnology. So, despite all of the ink that has been spilled theorizing about all the potential terrible consequences of gene patenting, there is in fact very little evidence that human gene patents unduly increase costs and reduce access to genetic research and medicine. So in relation to the benefits of patents discussed previously, there's also very little information with regards to whether patents in fact act to incentivize research in genetics, or whether genetic innovation would occur at a reduced rate if gene patents were not available. So there's really just not enough empirical data available to substantiate most of the concerns held by those who are either anti or pro-patent. This is partly because the consequences of human gene patents are very difficult to study. So there's a lot of factors that contribute to innovation, which makes it difficult to tease out the impact of each one of those individually. Additionally, there are very few counterfactuals where the impact of the absence of a patent could be compared to its presence in similar markets. That said, there's a lot of very intelligent researchers who are currently trying to gather empirical data on this topic, so it is possible that we'll know more in the future. So now that we know a bit about the theoretical benefits and drawbacks of gene patents, I'd like you to consider through discussion what kind of response you anticipate having to gene patents as genetic professionals. So consider both the research context and the treatment context. Would you ignore patents, as many of the professionals identified in the Hawkins paper did? And if you do think that that's the right approach, what justification is there for that, if any? If you came across a new genetic invention in your own work, and your organization encouraged you to patent it, do you think that you would do that? If so, how would you license your invention, if at all? So I'm going to pause the video now, and you can go ahead and discuss those questions. Alright, so now that you've had a little bit of time to discuss amongst yourselves what your own approach would be if you encountered gene patents in your professional endeavors, I just want to talk a little bit about some of the proposed solutions to the problems theorized in relation to gene patents that are currently in use. So the first of those that I want to discuss, the first kind of method for improving access and reducing costs of genetic therapies and research tools is compulsory licensing. So what this means is that there are provisions in most patent acts that when an official body or a court forces the patent holder, an official body or a court can force a patent holder to grant a license to a third party. The requirements for these kinds of provisions in national patent acts are set out in the World Trade Organization's TRIPS agreement, which is a treaty. The long form is trade-related aspects of intellectual property rights. And so this act describes, for example, how the licensee will usually still have to pay a reasonable fee, even when it's a compulsory license. And that license usually will not be exclusive, but rather the patented invention will be made available to anyone who can make use of it. So these kinds of compulsory licensing provisions do exist, and they come up in situations like for the purpose of protecting public health, say in the case of an epidemic. So the language used in relation to these kinds of protections of public health usages is you have to have a national emergency of extreme urgency. That's what TRIPS says. But countries can decide for themselves how exactly they want to interpret that language. So this seems like a reasonable option, like a useful option in those kinds of really extreme situations, but it's very rarely used in practice. So its utility, I guess, is somewhat questionable. So the next mechanism that has been proposed as a way of limiting the negative potential impact of gene patents is competition law. So competition law is generally used to prohibit the abuse of monopoly positions. But that said, the interface between intellectual property rights and competition law is quite complex and difficult to lay out in this context where we're doing a fairly surface level assessment. I'll just say that by nature, a patent confers a monopoly, whereas competition law is meant to prevent monopolies, and so they clearly can come into conflict with one another. Even though they're not sort of inherently opposed, because of course they do, in our current legal context, work together. So competition law may be seen as a complementary area of law that can help to regain some of the ground lost by patent monopolies. But in practice, the use of competition law is not really regarded as the best instrument to amend the problems raised by the patent system. It would be better to have something inherent to the system itself which deals with its problems. And so sort of relying on competition law after the fact just sort of overcomplicates things. So this is more of a sort of last-ditch emergency measure. So another mechanism to note is opposition and revocation procedures by the European Patent Office. So what I mean by this is that anyone can oppose the granting of a patent as long as it's based on one of the following three grounds. So first of all, you can oppose a patent to the EPO on the grounds that the subject matter of the patent is not patentable. You can oppose the granting of a patent because the disclosure of the invention is not sufficiently clear and complete. So this speaks to that patent bargain that we talked about, whereas somebody should not be able to get a patent if they're not fully disclosing their invention and providing society with the benefits of it. And thirdly, someone can oppose the granting of a patent before the EPO if the scope of the granted claims extend beyond the content of the application as filed. So this relates to that problem that I mentioned earlier about overly broad claims, where somebody is getting a bigger monopoly than they sort of deserve, so to speak, given the actual diameter of their invention. So this is a mechanism that is currently in use. It occurs with about 5% of patent applications. 2/3 of those cases result in the patent being amended or revoked. So this is a mechanism that appears to work fairly well within that limited context of patents that have already been granted. So an additional mechanism that we can talk about is national court proceedings, where people can challenge the validity of a patent that's been granted. So this is probably the most common mechanism used for preventing the application of improperly granted patents, but it's also fairly problematic within the EU context, because what happens is it creates uncertainty between nations. So for example, if you have used the same patent application to get a patent on a particular invention in Spain, and also in France, and somebody in France challenges the validity of your patent, and it's found to indeed be invalid, the patent would still be valid in Spain because this is a national mechanism. So it creates a lot of problematic inconsistencies. Additionally, it's very costly. Litigation is always incredibly costly, and patent litigation in particular. So while it is the most commonly used mechanism, it is problematic for a number of reasons. So one last mechanism that I want to mention is a research exemption, which is also referred to as an experimental use exemption. People tend to be quite positive and excited when they hear that there's a research exemption, since a lot of the problems that human gene patents seem to cause relate to access to research tools. But what a research exemption actually means is that there's a possibility for unlicensed use of a patented invention in pure research, so long as that research has no commercial implications. So it's fairly limited. This, again, it sounds good for promoting genetic research, but many people wrongly believe that the research exemption allows further scientific research using the invention, when in fact it only allows research on the invention itself. So what I mean by that is that, for example, if a physician a researcher wants to perform a diagnostic test, they're no longer doing research on the test itself, but rather they're making use of the test as a tool to promote their own research. So a research exemption wouldn't apply in that kind of a case. So generally speaking, the scope and limits of a research exemption are pretty narrow, as well as being somewhat unclear, because they're differently interpreted across Europe. What exactly their scope is interpreted somewhat differently from country to country. So overall, while this sounds like a promising mechanism, it actually needs a bit of legal clarification, and needs more people to sort of test it before it can really be seen as something useful. So in addition to these mechanisms, there are a whole bunch of other kind of novel proposals for how to deal with the problems that people theorize are going to be caused or are being caused by human gene patents. Most of these are fairly untested. As I mentioned, there's not even a lot of evidence that the problems people are theorizing are in fact occurring. And so, of course, the solutions to those problems, you can't really test those either at this point. So I'm kind of going to just leave you with those concrete examples that are in effect that I've listed already. Alright, so I hope that you have enjoyed this lecture and my previous lecture as well. And again, I apologize that I couldn't be there to speak to you in person. But if you would like to get in touch with me, please do not hesitate. I'd be very, very happy to hear from any of you, and you can reach me at my email below. Thanks very much.